you, Rose, and thank you, ladies and gentlemen. It's a pleasure to undertake this task this evening. When Rose invited me to launch the issue, she sent me a complete set of all the papers that were to be published. And I looked through them with great interest, and I must say that I echo Lachlan's comments that the issue contains a wonderful collection of excellent papers on a really wide range of topics, many of which I had never considered before, but I found intriguing. I also found intriguing that it included a paper by my friend and colleague Ronald Sackville entitled Law and Poverty, a Paradox. In the bundle I was sent, it was just about the last paper. I went next door and asked Justice Sackville why his was the last piece. Unfortunately, he had already received the published version and knew that that was not so. He pointed out to me that it was number 3, not number 10. My mischievous question fell entirely flat, but I must say he was not unusually despondent, or rather unduly despondent. He's usually despondent. But he also expressed his warm approval for the quality of the editorial work, and I thought I should pass that on to those of you who may have worked on it and are present. Actually, his was not even the last of the collection I was sent. There was a paper which complements the one I'm about to speak on, which I should mention, which is that by two Adelaide-based writers, Laura Grenfell and Sarah Moulds, on the role of parliamentary committees scrutinising bills for human rights. Anyway, if you have a copy of the publication, you will realise that the papers are in an entirely logical and appropriate order. But let me turn to Jacinta Dharmananda's paper on using parliamentary materials in statutory interpretation. I think Jacinta Dharmananda has two purposes underlying this piece. First, she thinks, broadly speaking, that those of us who read and construe statutes for a living should better understand how they are created. I have much sympathy for this view, but it immediately reminds one of the adage attributed, apparently mistakenly, to Otto von Bismarck: "Laws, like sausages, cease to inspire respect in proportion as we know how they are made." Dharmananda's more specific purpose is to encourage an understanding of the sources, timing, and purposes behind parliamentary materials which are called in aid in the process of construing a statute, but usually with little idea as to their original provenance. To that end, she hopes we will avoid the stinging critique of the use of such material, also the subject of a well-known aphorism ascribed to Judge Harold Leventhal of the DC Circuit Court, who once likened the use of such material to entering a crowded cocktail party and looking over the heads of the guests for one's friends. As Antonin Scalia and Brian Garner wrote, after quoting Leventhal, "Because there are no rules about which categories of statement are entitled to how much weight, the history can either be hewed to as determinative or disregarded as inconsequential as the court desires." As Dharmananda explains, this article is part of a study being undertaken by her for a doctoral thesis at the ANU. I think the project is timely. It is timely because there appear to be tides in the affairs of statutory interpretation. There are peaks and there are troughs. The trough we have recently passed through has been described as the new textualism. It was characterised by a dismissive attitude towards the concept of legislative intention and, concomitantly, limited interest in extrinsic materials. There is some irony in the fact that this last trough arose shortly after Parliament had legislated to ensure that courts could take account of extrinsic material, such as second reading speeches and law reform reports, in construing legislation. Perhaps familiarity with the process of legislating indeed bred judicial contempt, as Bismarck might have predicted. The most cogent dismissal of reliance upon parliamentary materials was expressed by one of your staff, former President Mason of our court in 2008, in Harrison and Melham, in support of the proposition that a minister's understanding of the effect of a statute or the state of the common law cannot give the bill he or she is promoting an effect inconsistent with its terms as construed by the court. He called in aid language to similar effect in Re Bolton Ex Parte Bean, in a joint judgment of Chief Justice Mason of the High Court and Justices Wilson and Dawson. As President Mason, himself a former Solicitor General, noted, these three justices were former Solicitors General, who may perhaps be taken to have had some awareness of the capacities of busy ministers seeking to expound a bill and or persuade the Parliament to pass it, to be prone to the gamut of human imperfections to which we are all subject. Although she does not directly refer to these observations of the then President, Dharmananda does refer, in a footnote I add, to a passage in my judgment in Shorten and David Hurst Constructions, in which I questioned aspects of the reasoning in Harrison and Melham. I note in passing that Pearson-Getty's statutory interpretation in Australia refers to Harrison Melham but not to Shorten. Perhaps it's not only judges who survey the crowded room in order to select their friends. I realise that in speaking of peaks and troughs, I have strayed into an implicitly value-laden image. If I say that, led by recent decisions in the High Court, we are coming out of the trough, I may be understood as implicitly approving a change in course, despite the fact that the image of a tidal system conveys a degree of inevitability. However, let me make my approval explicit. And in doing so, I do recognise that there is always scope for scepticism about the value of the exercise. But I think we have been through a Humpty Dumpty phase. You all know the passage in Alice in Wonderland. When I use a word, Humpty Dumpty said, in a rather scornful tone, it means just what I choose it to mean, neither more nor less. The question is, said Alice, whether you can make words mean so many different things. The question is, said Humpty Dumpty, which is to be master? That's all. The dismissal of legislative intention as a fiction allows the court to be master, to determine the meaning of the text with little regard to what was done or said in Parliament. Of course, the judge is not being Humpty Dumpty. He or she does not choose the words. Parliament does, but the court decides the meaning. As we all know, context is everything. In principle, it is difficult to justify an approach which imposes strict limits on what the court may take into account in construing legislation unless we diminish the role of Parliament. That is not to say that there should not be limits, and further, that pragmatic considerations are not relevant. They are, of course. It does suggest, however, that awareness of the imperfections of the parliamentary process might suggest the importance of improving one's general understanding of that process rather than rejecting its product on the basis that it sometimes may be flawed. I think that Dharmananda would say that the insights enjoyed by former Solicitors General who are appointed to the bench should be more broadly shared and more rigorously applied. An understanding of parliamentary process is a highly desirable backdrop against which to understand how, in general, legislation is processed. For example, there was a report in the news this week that the clerks of the Senate and the House of Representatives had made submissions to a parliamentary joint committee on intelligence and security inquiring into the Foreign Influence Transparency Scheme Bill 2017. Who invented that name, I wonder? A bill designed to expose lobbying and possible interference by foreign governments. Dharmananda seeks to explain the process by which bills are referred to particular committees, at what stage such a referral may take place, the makeup of the committee, and the procedure it adopts, including the cases in which it may call for public submissions and conduct hearings. And of course, other forms of extrinsic material may be important. That is especially true of law reform reports, and the more so if accompanied by draft legislation, as is now common practice. The use which courts make of such reports is quite variable. About 4 years ago, our court and later the High Court had to consider various aspects of the Foreign States Immunities Act 1985, a Commonwealth statute, in a case called Firebird Global Master Fund and the Republic of Nauru. The Act was a product of a report by the Australian Law Reform Commission. The report was unusually authoritative. The Commissioner in charge was then Professor James Crawford, an international law expert. It was accompanied by draft legislation and even a draft explanatory memorandum. The Act drew closely to the draft legislation. Unsurprisingly, all judges in both courts paid close attention to the report. However, that is not always how law reform operates. An intriguing piece of history is to be found in a recent article by Professor Paul Mitchell from Cambridge of the manner in which the UK Law Reform Contributory Negligence Act 1945 was prepared, that being legislation which was the basis for the 1965 Act in this state. The need for reform of the law with respect to contributory negligence led, at the suggestion of Lord Wright, himself one of the judicial critics of the then present law, to the establishment of a law revision committee, chaired by, of course, Lord Wright, and involving eminent experts, Stalabras, Winfield, and Goodhart. The outcome was not in doubt. The defence was to be abolished in favour of the current scheme. The drafting, nevertheless, has given rise to difficulties for over 50 years. Professor Mitchell noted that the Law Revision Committee did not produce a draft bill. He continued, "Within each of the official stages of law reform was a small group of individuals representing a small minority of those entitled to contribute, whose ideas and influence carried weight. Furthermore, each stage of the process was not of equal importance. The parliamentary stage, which we might expect to be crucial, was in fact a sterile formality. Key individuals made sure that it stayed that way. Being a consultant to the parliamentary draftsman, by contrast, was an apparently marginal role that, in fact, was just about the most powerful position in the process. The theory of how law reform should occur," he said, "bore no relation to what actually happened." Now, although that experience may be somewhat dated, it should not, I think, be assumed that there are not echoes in contemporary experience. Of course, most legislation does not emanate from law reform commissions, but is prepared within the government with varying degrees of outside input. That can be true of substantial legislation as well as more mundane reforms. Let me give you two examples. The drafting of the Native Title Act 1993, the Keating government's response to the Mabo decision, was assigned to then Attorney General Gareth Evans. He conducted a process in Parliament House of consultation and negotiation with Indigenous leaders from across the country. In the course of one fraught session, Evans was convinced by the late Ron Caston QC, who was the primary legal advisor to the Indigenous leaders, all of whom I might say were in the room, that a particular provision was essential to protecting Indigenous interests. Politically, however, Evans saw difficulties. He told Caston that the government might be able to accept the proposed provision if its purpose could be made less obvious. He adjourned the discussions to allow the lawyers to come up with a more acceptable draft. As Basten was toying with the language, he remarked, "One day I will be before a court seeking to rely on this section, and the judge will say to me, 'Mr. Basten, is it possible that the drafter could have made the meaning of this provision more obscure?' I will reply, 'No, Your Honour, we tried, but we could not.'" The government accepted the result. In his judgment in the Wick case, Justice Gummow stated, although not in relation to the native title legislation, "I begin with the proposition that for a statute such as the Queensland Land Acts, to impair or extinguish existing native title, or to authorise the taking of steps which have that effect, it is necessary to show at least the intention manifested clearly and plainly to achieve that result. In this context, intention does not refer to any particular state of mind of the legislators who may not have adverted to the rights and interests of the Indigenous inhabitants. Moreover, statute law may be the result of a compromise between contending factions and interest groups and of accommodations between and within political organisations which are not made public and cannot readily be apparent to a court. The Native Title Amendment Act 1998, which followed the Wick decision, involved an even more extensive process of consultation and negotiation than did the original 1993 Act. Perhaps because the then government was perceived to be less friendly, the leading Indigenous organisations combined to form the National Indigenous Working Group. The NIWG hired a number of lawyers, of whom I was one, and a former parliamentary council to negotiate with the government over almost every clause of the lengthy bill and to propose alternative and additional provisions. As I recall, the process took some 6 months. The negotiations encompassed not merely government officers, particularly Robert Orr QC and Philippa Horner, who exhibited the highest level of professional responsibility, but were also undertaken with representatives of the opposition, again Gareth Evans, and the minor parties who between them controlled the Senate. Whether, as promised by the then Deputy Leader of the government had delivered bucket loads of extinguishment is for others to judge. The process and the compromises reached could never, as Justice Gummow correctly noted, be conveyed to a court construing that complex legislation. With these somewhat random remarks, I commend Jacinta Dharmananda for her valuable article. I commend the editors for the excellent work they have put into the preparation of this issue. Volume 41, issue number 1 is duly launched, and I wish it bon voyage. Thank you.